SJC-11483, Commonwealth v. Jose Guzman.
Let's proceed. Morning.
Good morning. May it please the Court, my name is Thomas Boshin. I'm from the Attorney General's Office, and I represent the Commonwealth in this matter. With me is Assistant Attorney General Timothy Wise, who handled these proceedings in the Superior Court. The GPS monitoring provisions of Section 47 were mandatory and should have been imposed here. I'd like to begin with a point that the Commonwealth made in the last case and that the Commonwealth again repeats here, which is that this Court shouldn't decide the constitutional issues in the absence of further record development on the same types of issues that the Commonwealth just mentioned in the last case. However, to the extent this Court decides that the record is adequate, it should decide the issues in favor of the Commonwealth. Both this Court and the United States Supreme Court have applied a balancing test in deciding whether searches and seizures are constitutional. Here, the balancing test weighs in favor of the Commonwealth. The Commonwealth has legitimate interests here in promoting rehabilitation and in protecting the public. In terms of rehabilitation, first, the GPS monitoring device serves as a practical means of making sure that the defendant complies with the geographical exclusion zones, which he hasn't challenged here. Those exclusion zones are important not just for contact offenses, as the defendant points out, but also to keep him away from children, because the nature of the offense demonstrates that he finds children to be a certain, children are sort of the target of his inappropriate viewing, and keeping him away from areas where he's definitely going to encounter them can help him avoid the temptation of, again, going to view more inappropriate images of children. It also protects potential victims in areas where he's been deemed likely to offend.
But this is a internet, downloading pictures, right?
But it's more than just still pictures. These were movies of
Okay, but in terms of geographical locations, I guess I'm confused. What's the connection? As in the last case, there were no geographical limitations put on because of the nature of the offense.
Here, though, in fact, there were geographical locations.
But I'm trying to understand them. What's the relevance of the geography to this offense?
I think that the relevance is that the exclusion zones were, he's demonstrated an inappropriate interest in children. The exclusion zones are areas where he's very, very likely to encounter children: schools, playgrounds, children's sections of libraries. And exposure to children, there's not just a...
Okay, so I see that's what it is.
Right, it's not just a risk of recidivism, but it's also exposure to the children in terms of not just a hands-on offense, but also being exposed to the, I hate to use the word stimulus, but the children are the stimulus for the sexual viewing that he engages in online. In terms of his interests, they're significantly diminished. He's obviously a probationer, which diminishes his expectation of privacy. He has other conditions that he either hasn't challenged or has challenged and have been resolved that diminish his expectation of privacy even further. And in this case, if it is imposed, he'd not only have the statutory notice, but we'd make sure that he also had the verbal notice at a sentencing hearing that this condition was going to be placed upon him. In terms of the due process analysis, the defendant...
You said he had the verbal notice at the...
I said if this is remanded and it's imposed after this case and the other one, we'll make sure that there's verbal notice at a sentencing hearing that the
Well, in this case, there was discussion. The judge just was of the view that it was discretionary, and therefore she chose not to impose it.
That's correct. That's correct.
And do you agree that if it is remanded, the judge has the authority to reduce the length of probation?
She said that he'd be allowed to withdraw his plea, and we don't challenge that. Before the single justice, we didn't, and I'm certainly not going to take up a different position here. In terms of the due process analysis, unless the Court has further questions on the Fourth Amendment issue, the defendant has pointed to several federal cases basically urging this Court to adopt a a strict scrutiny analysis with compelling interest in narrow tailoring. I'd direct this Court to Jackson, which was a mandatory minimum sentencing case cited in the Commonwealth's brief, and to Power, which was a probation condition case. In both of those cases, this Court adhered to the reasonably related test. It did not apply a compelling interest test. The federal probation scheme is a bit different in that the statute there requires it the condition to be no greater than reasonably necessary. It sort of envisions a narrow tailoring. There's no similar statute here, so there's no reason for this court to turn away from the analysis that it's applied in Jackson and in Power. And in terms, finally, of procedural due process, excuse me, I'm sorry, there's no risk of an erroneous deprivation here. This could only be imposed after a trial or a plea colloquy where the defendant has admitted to the facts that constitute the offense, and it would be imposed as part of his minimum sentence. It wouldn't be like, for example, the sexual offender registry requirements, which are a separate civil scheme and a separate burden upon him. It would be part of the minimum sentence that he would be given.
The procedural argument really turns into a substantive one, right? In other words, that it's violative of substantive due process to have a mandatory everybody who's convicted of a sex offense gets this, as opposed to an individualized determination. I mean, I thought they sort of got merged a bit.
I think it's fair to say that they're at least related, if not merged, that he's entitled to an individualized determination because parties that commit I think for one example that's given is that parties that commit non-contact offenses are unlikely to commit contact offenses. Again, to sort of go back to the point I made at the very beginning, that argument came in sort of for the first time here on appeal before this court with some studies. The studies themselves acknowledged their own limitations, and it seems like before an act of the legislature that's presumed constitutional is struck, there should be a bit more development as to the validity of the studies and what in fact they do or don't show. Unless the court has other questions, the Commonwealth will ask the court to vacate.
But with regard to reasonable relation, you're not saying reasonable relation with regard to a particular offender. You're saying reasonable relation in general?
With respect to due process, right to the goals of probation, which would be rehabilitation, protecting the public.
Okay, so your view is that it would be irrelevant if a defendant could demonstrate that that particular person is not a strong candidate for this because there is no meaningful risk of a contact offense?
I think that the legislature has made, I think the answer is, in most cases, yes, the legislature has made the determination here that this narrow class or this class of sex offenders should have this provision imposed as part of their minimum sentence. And this court has said that there's no constitutional right, absent, of course, cruel and unusual punishment concerns to individually tailored sentencing. So I think unless there was a valid cruel and unusual punishment argument or something that I just can't imagine as I stand here on my feet.
Well, you could theoretically come up with a substantive due process one if it had absolutely no relationship to the crime at all. But you're saying whatever that minimal standard is, it's met by classifying all sex offenders to be required to have this. I think that's here.
Yes, I think that's right. The legislature has sort of made that determination here, and it's not a case where there's absolutely no possible way to think that it was reasonably related or connected. Unless the court has other questions, the Commonwealth asks the court to vacate and rest on its brief.
Thank you.
Good morning, and may it please the court. Last year in Commonwealth versus Rousseau, this court held that the police cannot attach a GPS device to a car and use that device for the purpose of monitoring the car's movements unless there's judicial oversight and a showing of individualized suspicion.
Mr. Rousseau had not been convicted of a crime, right?
That's correct. And
why doesn't that make a huge difference here?
Well, the difference that makes is the difference that it made in Commonwealth versus La France, where 25 years ago, this court weighed the competing interests of the public interest in ensuring that probationers comply with their conditions of probation, do not recidivate, with the Article 14 expectations of privacy of probationers. And what the court held was not that probationers have no expectation of privacy and therefore can be subject to searches and seizures without any individualized suspicion, but rather that the level of suspicion that's needed is not full probable cause, but reasonable suspicion. So all we're asking is that this court apply the holdings of Rousseau and Conley, which make clear that attaching a GPS device to a car, let alone attaching it to an actual person's body, and then using that device to to monitor movements. In this case, it would
But
be.
that's so different. It's reasonable suspicion to believe that criminal activity is taking place versus someone who's convicted, and we're really talking about, at most, reasonable relationship to the sentencing of someone who's been convicted.
So
I don't understand how reasonable suspicion, as you've described it, comes into play here.
Well, it comes into play because GPS monitoring is a search and seizure. It's a seizure of his body by attaching a device to his body.
But reasonable suspicion, but it's reasonably related. It's a punishment here, reasonably related to the goals of probation in these kinds of cases. The legislature has made that determination.
Right. So, well, the judge here found that it wasn't reasonably, well, implicitly found that it wasn't reasonably related to the goals of probation. Now, what the other side says.
Judge made that finding as when she said, "Oh, this is so broad."
Well, she also said it would result in ridiculous things. So I think resulting in ridiculous
A
things
finding
is an
of
implicit.
fact? Is that a finding of fact, or was it just her?
I'm not sure that it needs to be
Her.
I'm not sure that this court has ever required that it's a finding of fact. It's a legal conclusion that's not reasonably related. And I think resulting in ridiculous things and not reasonably related to the goals
That
of
was her
probation
legal
are
conclusion.
functionally equivalent.
That was her legal conclusion with respect to GPS in this case.
I think that's correct, Your Honor. Now, what the Commonwealth claims here is that this reasonably related test can be applied not on a case-by-case basis, but to by the legislature, to an entire category of probationers. This has never before been, I'm sorry.
No, I'm listening.
This has never before been done in any other case, where rather than having a determination in an individual case that this deprivation of liberty is justified by the facts of that case, that this can be done for an entire category of cases.
But we have mandatory prison sentences for categories of cases.
Except there's the fundamental difference between those two things is that there is no requirement that any sentence of imprisonment be reasonably related to the goals of sentencing. But this court has made clear that that is true for probation. That's an important recognition because of the spectrum of punishments. On one side of the spectrum, we have imprisonment, where people essentially give up all of their liberty interests. On the very other side of this spectrum is probation, where people retain significant liberty interests. And before we are going to deprive those people of their fundamental rights or their constitutional rights, there has to be a showing that that is justified. And the test that's been applied, of course, is the reasonably related test. Now, what the other side wants is for this to be applied by the legislature, this whole category of cases. Now, I don't think that this court's precedent supports the idea that this can be done anything but a case-by-case basis. But even if it could, it would have to be done with a narrowly drawn statute. And this is not a narrowly drawn statute. Instead, what the legislature did was took this broad definition of sex offender from the sex offender registry statute, then took it over here to the GPS context, and then applied it without any narrowing. So that definition includes people like the defendant in front of the court here who possess child pornography within their own homes. It also includes the female offender from the Doe case that was decided last month who committed a sex offense, but a sex offense that had purely a financial motivation and where GPS would make no sense, wouldn't do anything. And to see what a narrowly tailored statute would look like, what you can do is look on page 24 of the Commonwealth brief. They list, I think it's 22 other states that have enacted what they consider to be equivalent GPS statutes. But if you just look at the first of those statutes, it's an Alabama statute. And it's an Alabama statute that requires GPS monitoring only for sexually violent predators. And a sexually violent predator is narrowly defined as somebody who is a repeat sexually violent offender or is a first-time sexually violent offender, but there is a specific finding that that person is likely to engage in one or more sexually violent offenses in the future. So GPS monitoring in that context in Alabama is tailored to those people where it actually does something, rather than applying it to cases like this case, where the defendant has no history of contact offenses. His only offense that got him placed on probation was possessing child pornography that he received through the internet. So what we have in here is a statute that is overly broad, and in cases like this, as the judge found, it just doesn't make sense and results in ridiculous things.
So if the legislature were, if we were to do what you want and say you cannot do this with regard to non-contact offenders, which I guess is what you're asking us to do, correct? It has to be we have to be discretionary with regard to non-contact offenders?
Well, I'm not saying that it couldn't be applied in any non-contact cases. There could be a case where somebody commits a non-contact offense, but as
But
a
it has to
prior.
be individually determined.
That's right.
And if the legislature then says, well, we're then going to impose a mandatory sentence for all non-contact offenses so as to ensure that they won't do any harm, because if we can't monitor them with GPS, we'll make sure they're in jail. That they can do?
They could do that, but
So why can they do the more severe without doing the less severe?
well, I think this is true in general of probation. Ms. LaFrance, had she been sentenced to prison, which she could have. In fact, the judge said to Ms. LaFrance, you either agree to these conditions or I'm sending you to jail. The judge could have not given her that choice, could have just sent her to jail. And then she would have been subject to suspicionless searches throughout her entire period of incarceration. But she was placed on probation, and because she was placed on probation, she retained her expectation of privacy, and therefore searches could not be conducted of her or her residence unless they were based on reasonable suspicion. And this, all I'm asking is for the same standard to be applied here. This court has already recognized that GPS monitoring is a search. It's a search because it monitors the person's movements, and it is also a seizure because unlike, I think, any other state action that I'm aware of that flows from a criminal conviction or otherwise involves actually physically attaching a device to a person's body and then requiring that device to stay attached for the entire period of probation, here 5 years. And because it is a search and a seizure, under LaFrance, even though she is a probationer, she retains enough, or he retains enough of his expectations of privacy that that search and seizure cannot be conducted unless there is reasonable grounds to believe that he is going to engage in misconduct. And I think this issue that came up during the Commonwealth's argument about whether exclusion zones can be established, well, I think there is some question about whether exclusion zones could be validly established under footnote 10 of Corey. This court did recognize that where somebody merely possesses child pornography in their own home, it wouldn't make much sense to establish exclusion zones. Here, there were exclusion zones established with the assent of the defendant, and we don't object to those here. But it's a different question of whether exclusion zones can be validly established and whether GPS monitoring can be ordered to enforce those exclusion zones. And this isn't unique here. If we look at the LaFrance case, there were surely, Ms. LaFrance had been convicted, I believe, of receiving stolen property. It certainly made sense that in order to enforce her conditions of probation, that they might want to look in her house and make sure she's doesn't have additional stolen property. But just because there is a valid condition that says, say, don't steal property, doesn't mean that we can then deprive somebody of additional constitutional rights in order to enforce that validly imposed condition. Another example, I think, is from the appeals court's decision in Gomes, where they said that drug testing could only be conducted if there was reason to think that the person actually was going to abuse drugs while on probation. And in that case, there was a valid condition of probation, wasn't contested by anyone, that he not use drugs, or actually it's drug and alcohol testing, or alcohol. Those were both valid conditions of probation. But that didn't mean that suspicionless searches conducted by forcing him to do drug testing would be lawful without some basis for believing that he was actually going to abuse drugs and alcohol while on probation. And that is all that we're asking here. The only difference here is that there is a statute that was enacted that requires it. But never have statutes been permitted to trump constitutional rights. It goes the other way.
Well, the statute is presumed constitutional.
It is presumed constitutional.
Have you met your burden of proving beyond a reasonable doubt that it's not?
Yes, and the reason why is this is merely a combination of two lines of case law, on the search and seizure issue at least. You combine this court's recent search and seizure case law relating to GPS monitoring, which shows without any shadow of a doubt that forcing somebody to have a GPS device on their ankle for 5 years of his life is a search and a seizure. And then this court's 25-year-old precedent from La France that says we don't permit suspicionless searches of probationers. And I'm not asking the court to impose the full protections that normally apply when the state wants to search someone or seize a person's body. All I'm asking is that this court apply the reduced level of suspicion that the court required in La France. And the same with the due process claim. The claim here is not that there is a great burden placed on the state before they can impose the burden of GPS, but rather that they meet the simple test of being reasonably related to the goals of probation. But because the definition of sex offender that was adopted by the legislature and applied in this GPS context from that unrelated sex offender registry context is so broad, it's going to include cases, unlike the Alabama statute, where it just is not needed. And I think that the contrast with sex offender registry is important because this court has already recognized that GPS monitoring imposes greater burdens than sex offender registration. But unlike a defendant who is ordered without any possibility of showing that he does GPS monitoring isn't needed, somebody who's placed on probation, GPS monitoring under Section 47, mandated, no possibility of showing that it doesn't apply, that same person can go in front of the Sex Offender Registry Board and say, I don't pose any risk.
Well, let me just ask you this, though. If you agree, as you have, that the legislature could say, all right, we're just, no probation, they're just going to, people that commit sex offenses are going to just do 2 more years of a sentence and stay in jail. And as we have concluded that GPS monitoring is a punitive condition, why wouldn't we look at it as part of, I mean, it is part of the sentence. In other words, it's a punishment that goes along with this crime that's grafted onto probation, but it is a punishment that goes along with the sentence of this crime. So it's not like looking at the invasion of privacy that GPS monitoring does by itself, because it is intended to be a punishment.
Well, yeah, a couple of responses. The first response is, if it's intended simply as a retribution, this would be, I think, unprecedented, that the court would endorse searches and seizures of people as punishment, because that could have justified La France. That could, that would do away with the holding in La France.
That was was that a statute or a?
It wasn't a statute, but it was a constitutional rule. So once again, we would be saying that the legislature can change the constitutional rule that was announced in La France, and that certainly can't be. You have even when you're on probation, I suppose, and then the second response is that there is a difference between people who are placed on probation and those who are incarcerated. When you are on probation, you retain certain constitutional rights, and those include the constitutional right to not be subjected to suspicionless searches and seizures, and that's exactly what would be ordered here. I see my time's up, so if there are no further questions, I'll rest on my brief.
Thank you, counsel.
Thank you.
We'll take our morning recess.
All rise.